And firstly, I wanted to just say, I want to thank you and the rest of your team for putting together such a beautiful journal, especially during the pandemic. It's something that you guys should really be commended for. And congratulations to everybody on the journal's editorial board for all of your hard work. And also thank you for all of your comments, which helped me make this article what it is right now. I began writing the article during the height of the refugee crisis in Europe some years ago. And over time, it's seen various iterations. Neve and I have had discussions about this. And we've also sort of come to an understanding that the current models that I've proposed would be applicable to refugee crises everywhere and not just with respect to what happened in Europe a couple of years ago. My paper seeks to do two things when analyzing the efficacy of the human rights framework that's applicable to refugees. The first thing that I seek to do is to understand whether an obligation of internationally shared responsibilities for refugees can be located in international law. And the second thing that I tried to do is to provide a solution to the problem of prioritization in refugee law, which is basically a problem involving prioritizing the rights of a citizen over the rights of an asylum seeker. Now, my objective was to create a discourse on the need for a state of origin of a refugee to actually share the burden of caring for the refugee with a recipient state. The central theme of the article was basically to establish a model which would assist states in determining how to distribute their resources, scarce resources, in a way that maximizes access to human rights. Now, we all know that refugees are quite a disenfranchised population. They're one of the most disenfranchised populations in the world, and they only rely on the benevolence of a host state to take them in. We also hear that refugee camps are always in a bad state, without food, without water, without basic human rights. And things like education and health are really a far cry. But is the benevolent host state really to blame if the living conditions are this terrible? Do they have the resources? When they don't have the resources, what do they do? Well, the deal is when their resources cannot be shared equitably without compromising on the rights of some individuals, it's a hard question for a state to answer whose rights they should seek to prioritize. Now, of course, it's only natural for a state to have a sense of loyalty towards the rights of its own citizens rather than the rights of a foreign refugee. So that is the first problem with the current framework in refugee law. Because one, it provides no incentive for states taking refugees in to provide them with adequate human rights on the same comparative level as the rest of their population. Now, this is especially bad considering that states would need to transfer resources away from their own citizens' use to care for refugees. But in international law, every person fleeing persecution actually has a right to seek asylum. So you're sort of forcing a state to take people in, but you're not doing anything to tell the state about how they should deal with those people once they've been taken in, or rather, what they should do when resources are very limited. Concurrently, states also have an obligation of non-refoulement under Article 33 of the Refugee Convention. Now, what this means is that no state can expel or reject someone who's an asylum seeker, especially if those people are part of an influx that's been triggered by state persecution. So if a state is unable to determine who is a refugee during a mass influx, it's actually bound to offer protection to such people and provide them with basic minimum standards of treatment. But on the other hand, a state isn't obligated to prevent the flow of refugees. And that's where there is a problem with the refugee law framework as it exists. The Refugee Convention does not have an obligation to avert refugee flows. In fact, there's barely any soft law practice on this. There's very little state practice to even support holding states liable for the migration of their nationals to other states. So far, seeking financial assistance and burden sharing in the cases of refugee crises has only been limited to calls for assistance on things like moral and humanitarian grounds. So you're literally relying on the benevolence of states. In fact, there's only one known instance of payment for causing the flow of refugees, and this was when Germany paid Israel after World War II for causing the flow of Jewish refugees. That payment was also recorded in the agreement to be only ex gratia. What this means is that it wasn't out of a sense of a legal obligation to pay for causing the flow of refugees. Now, the thing is, I've attempted to see whether we can actually make a state obligated to pay for the flow of refugees. And in my analysis, I've sort of analyzed that international law, with its wide variety of sources, is rather flexible. And the flexibility of international law forms the basis for my argument that there is a possibility to progressively realize an international law obligation to share burdens for causing the flow of refugees. This obligation, I argue, can actually be located in equity as a part of the general principles of law recognized by civilized nations. In the past, equity has been used to decide cases where existing principles are inadequate. So, for example, where a claim for compensation of refugee flow is considered unprecedented, the equitable solution would be to recognize burden sharing. And it would be something that would be in line with the case law of the International Court of Justice. Consequently, the state creating refugee flows should actually be made responsible for the resulting injury, since mass influxes actually place a huge burden on the receiving countries. Now, you might wonder how this would work. Pragmatically, the threat of sharing responsibilities would incentivize states to adhere to their obligations under international law and not cause the flow of refugees. But the sharing of burdens, no matter how little the burden is shared, would actually help address the host state's problem of needing to prioritize its own citizens over others, that is, the refugees. So even if a source state of refugees is incapable of providing financial support, or any support that it can give in the form of capacity building or otherwise would be welcome for the host state. Now, as long as the law moves towards recognizing the need to share responsibility for refugees, there could perhaps be an adequate mechanism not only to reduce intra-country inequality, but also reduce inter-country inequality. Now, in respect of the problem of prioritization, a large number of treaties, documents, and works that deal with human rights all have one thing in common. They acknowledge the equality of all human beings, particularly with respect to the inherent right to life. The right to life of the refugee is no less than the right to life of you or me. From that perspective, in one way or another, the guarantee of these rights should ideally not be dependent on the availability of the resources. But the unfortunate reality is that the guarantee of these rights for refugees is dependent on the availability of resources, or the lack thereof. Now, the problem of prioritization is not merely a problem of prioritizing one human right over another, but it's a problem of prioritizing one section of the population within a state over another section. The question that a state needs to answer, or rather the question that international law needs to answer, is can a state prioritize certain human rights of its citizens over the rights of those who migrate to its territory in search of refuge or asylum? Now, the most moderate line of thought is to use the proportionality approach to resolve any form of conflicts within human rights. It would be to ensure that the state receiving refugees provides these refugees with certain minimum standards of treatment in terms of food, water, and shelter, while then prioritizing its own citizens in those rights under the ICCPR and the ICASCR, which can be progressively realized. So the ideal situation or the ideal solution would be for each state to adopt a proportionality approach when determining what limitations must be placed on the human rights of refugees. Proportionality is an approach that says the graver the impact of the decision upon the individual affected by it, the more substantial the justification that will be required. Now, I conclude by saying that with its mechanism of balancing, proportionality is best suited to ensure substantive equality and minimal interference in the human rights of refugees. Now, these are key aspects missing in the current human rights framework, which is used to address the issues pertaining to the flow of refugees. Now, having said that, I think there is much to learn from whatever study I have done, and I can't wait to see what thoughts you might have, and I take any questions.